And thank you for the three of you and your testimony about your families. We really do appreciate your willingness to be here all day and make sure that we hear about your experience. I do want to ask you, because you said we are talking about the intent, where we're trying to go, making sure that a jury hears everything, right? The limited liability that I'm hearing you say if they only had $1 million and that's all you could get, and that doesn't come close to satisfying the $17 million in costs that you and your family are absorbing, aside from the emotional damage that you're telling me of not having your mother present in your life. Put that aside. What is your answer to this question that we have about this procedural phase 1, phase 2, and how this stuff comes in?
So,
And will you please pull the mic, because otherwise we don't get it.
so Representative LaHood brought up a question that needed to be answered more properly. He asked about subsection F, and it says specifically that an ordinary negligence claim against an employer or defendant for a claim such as a negligence maintenance claim that does not require a finding of negligence by an employer, by an employee as a prerequisite to an employer defendant being found negligent for its conduct or omission. He said that should bring in all the claims that we're looking for, but it doesn't. And the answer to why it doesn't, Representative, is because negligent entrustment and negligent hiring, which are the things that I was trying to bring up about the accident that happened on March 15th, or I think that's the date. Those findings about that he shouldn't have been hired because he didn't speak English and because he was over his hours of service, those are all negligent hiring and negligent supervision. Those require a finding of negligence. So F actually specifically excludes that evidence. And so then for it to come in, it has to be a direct proximate cause. And Representative LaHood left, but you didn't get a proper definition to proximate cause. He actually kind of alluded to it. He said, is it but for? So it is but for plus, and for those who aren't attorneys, I know that you are, Vice Chair, but so there's but for, like if it didn't happen, it wouldn't have happened but for, kind of like the butterfly effect. It has to be but for, but it also has to be foreseeable. So what I was alluding to, Congressman Leach, about
Don't call him that.
Look,
He's
oh,
just
I'm
a
sorry,
chairman.
Chairman Leach.
yeah,
I'm sorry.
don't accuse me of such malfeasance, please. I'm not a congressman.
Well, actually, I really appreciate what you did by pointing out that TTLE doesn't necessarily represent all trial lawyers. My membership in that organization is expired. They don't represent me. And so that was an important distinction for you to make. I'm not a Democrat.
Go ahead. Keep going with your testimony.
So what is important for you to know is that those claims, they're not always proximate cause, but they are a part of the bigger picture. Kind of like being a member of ISIS or being an Islamic extremist doesn't make you a murderer, but is a part of the bigger picture. If you're a U.S. attorney and you're prosecuting a man for murder, of course you're going to bring in his motivations. If you're a plaintiff's trial lawyer, of course you're going to bring in the bigger picture. There is a percentage of liability that should be assigned to the trucking company. We shouldn't have this Chapter 72 at all. We should just have jurors hearing all the facts and making a decision with the judge guiding them into what's the relevant evidence and making sure that extraneous things, prejudicial things are kept out. We should just trust our elected officials. We trust the legislature to pass the laws. We should trust the judges to control our courtrooms. That's all I'm suggesting. That's why I was alluding to James Madison and the Seventh Amendment. And we have a similar provision in the Texas Constitution. And I apologize that my career apparently made chicken sandwiches so expensive, but I can tell you, you can put me out of business. You can put me out of business by making our roads more safe, and then I'll have to go out of personal injury and go into divorces.
Let me ask, since you seem to get or be into this, why is there data that suggests that Texas has such a higher truck wreck percentage than any other state in the nation? What is it about us?
Well, I mean, it's a number of factors. I don't want to just blame tort reform, but tort reform is a big factor. We don't have enough nuclear verdicts. We need more nuclear verdicts. And we need nuclear verdicts that stick. If nuclear verdicts will stick in the state, and what I mean by that is, in the last 15 years, I believe only 3 verdicts of more than $15 million have been upheld by our appellate courts. Anytime a big verdict comes down, the appellate courts kick them back down. 90% of plaintiffs' verdicts are overturned in any size. Anytime an appellate verdict is reviewed by a trial verdict is reviewed by an appellate court, there's an 85 to 90% chance that it is overturned when it's a personal injury case. That is making roads more dangerous. There are no legislation, and if you look on the last page of this handout, it's a news report from CBS Austin that kind of answers your question in further detail. It's a member of the Trucking Safety Coalition talking about the answer to your question. We don't have any legislation pending in this legislature in this session to do anything to make our roads more safer, like speed limitations on trucks. And you alluded to some truckers are safe, but some are speeding. Well, we could have speed limitation requirements, like physical speed limiters in our trucks, but that bill's not pending before this session. We could have digital log requirements. We have digital log suggestions. We could take unsafe trucking companies off the roads. If you have hours of service regulation violations repeatedly, shut those companies down. Instead, we rely on the USDOT to come in and do audits. Well, they rarely get audited and they never get shut down. That's why and then of course there are the geographic examples that we're a very large state. We have a lot of highways. We have a lot of high speed limits. I won't blame the trucking industry. And the trucking industry came in here, or Lee Presley came in here and said, he admitted that this bill wasn't about lowering their premiums. Well, I don't want to shut down mom and pop shops. I run a mom and pop shop myself. I have an 8-employee law firm. And I pay high premiums too. I would like to see those premiums go down. If we're hurting trucking companies and they're cutting corners because of their high premiums and because of their other business costs, legislate those away. You have Department of Insurance, lower the premiums. They're making $190 billion, right? Cut the premiums and help them drive safer, help them hire better employers. Maybe they can raise their wages if they cut their premiums and they can get better drivers.
Thank you.
All right. Members, any other questions for this panel? Okay, thank you. Thank you all for being here. We appreciate it. Chair calls Jason Sprague, Jessica Sprague, Bradley Pearson, and Ty Turkett. The next panel will be Cynthia Garrett, I'm sorry if I pronounced that, Jody Scott, Melissa Traylor, and Victoria Limon.
Chairman Leach?
Yes.
Committee members, I'm Jason Jessica Sprague, attorney. They had an 8-month-old child at home. They waited for 11 hours.
That-
Just had to leave.
Okay, what's your name?
Matt Martin. They wanted me to apologize that they had to leave.
Are you registered to testify?
No, that's why I was making a statement.
Do you want to testify?
I can?
Yes, why don't you come over here while we start this panel, and you can't speak on their behalf, but you can testify as their attorney. So just to be clear, Jason Sprague is not present?
That's correct.
Okay, hang on. Sorry, the chair will show Jason Sprague registered against the bill but not wishing to testify. Jessica Sprague is not present either?
That's correct.
Okay, the chair will show Jessica Sprague as testified against the bill, registered against the bill, not willing to testify. If you could come over here, and Michael will help you get registered. So Bradley Pearson?
Yes.
And then Ty Turkett?
Right.
Okay, the chair calls Cynthia Jared? Okay, come on up. So the next panel will be Jody Scott, Melissa Traylor, Victoria Limon, and Marie Navarrete. Mr. Pearson, let's start with you. I've got you registered as Bradley Pearson on behalf of yourself testifying against the bill. Is that correct?
Yes, sir.
All right, go ahead.
My name's Bradley Pearson. My wife Leslie's with me today. We're from Newark, just north of Fort Worth, and we oppose House Bill 4688. 9 days ago was the 5th anniversary of the worst day of our lives. Our 28-year only son, 28 years old, was on his way to visit us when a cement truck turned left in front of him, hitting him head on and killing him. We got an attorney, we sued, pulled the driver cam. He was on his cell phone. He also a convicted felon. He'd been on the phone 55 minutes when he hit our son and killed our son. His claim was he never saw Blake, which is textbook inattention blindness, distracted driving. His cell phone records were pulled, compared with his driver log. In the 90 days previous before his death, the driver and another fellow driver, which both knew the company, Burnco, had a no-cell policy. They had talked 150 plus times in that 90 days while driving. Burnco admitted they didn't enforce their no cell phone policy. They're dirty. Our son could still be with us had the company enforced their policies. Nobody should lose a child. We're very close to Blake. We did a lot of things together. We're looking at land to buy together, to build houses on, build as a shop together. Leslie, my wife, took it very hard. She became suicidal and thankfully got treatment and got through that. This bill prevents jurors from getting full story of how the dangerous actions and unsafe employers like Burnco cause death and mayhem on our roads and destroy families in the initial phase of the case. If passed by you, this bill will allow dangerous companies that don't enforce their own safety rules to escape full responsibility for killing and injuring Texans. It puts all of us in danger on these roads. We're all gonna get in the car and drive home tonight. It could happen to any of us, so that's what I gotta say. Thank you.
Okay, I'm very sorry for your loss. You said your wife is in the room as well?
Yes.
Okay, sorry for both of your loss. I just cannot imagine anything worse, and we appreciate you being here to testify. Ty Turkett, Ty, I've got you here registered on behalf of yourself testifying against the bill. Is that correct?
Correct.
All right, go ahead.
My name's Ty Turkett. I live on a ranch approximately 12 miles west of Waco, just outside of Valley Mills, Texas, in between Life and Highwater, in the road, and I leave the turn. been break. Let the sister give a baby neighbor. She was mobile for a while, injured. Man, worked till 2 suffered lost his instruction and called it up for Harry Chris.
I've got you here on behalf of yourself, registered against the bill.
Correct. Good evening. My name is Cindy Jared. I am here today with my husband Juan and our granddaughter Emery. We are from North Lake, a small town north of Fort Worth, and we are here to oppose House Bill 4688. On the morning of February the 11th of 21, while on her way to work at the Tarrant County District Clerk's office, our beautiful 34-year-old daughter Tiffany Jared was killed when an inexperienced truck driver pulling a trailer for FedEx carelessly plowed into her car. Not only was the driver not using caution on the icy toll road, when he slammed into Tiffany, he was driving so fast that the truck and the trailer ran over the top of her car, killing her on impact. As a mother, it crushes my heart to know that Tiffany did not have time to escape her car, and I can feel the fear and the helplessness that she must have experienced in her final seconds when she could look back and see the 18-wheeler coming at her. We were never able to say goodbye or to hold her hand or kiss her cheek. That morning, we lost our only daughter, and our 4 sons lost their sister, and at the young age of 11, Emery lost her mommy. That day in Fort Worth changed our lives forever. Tiffany had the biggest personality and was full of life, and it was taken from us in a matter of seconds. With the laws in place today, we are currently in the process of holding accountable not only the drivers, but the FedEx Corporation and all the trucking entities. Some of those are foreign companies operating in Uzbekistan and Russia. These companies do not care about Texans or our safety, but you, as our elected officials, you do care. You do care about protecting your own families. And I believe you feel that you should protect us from this bill. Victims and their families should have the right to hold these companies accountable when their negligence causes death and catastrophic injuries to their loved ones. Thank you for your time.
I'm so sorry for your loss, Ms. Jared. I remember that terrible day and that accident in Fort Worth, and just cannot imagine. Can you read that last sentence you just said? Maybe the last 2 sentences of your statement. Can you read those?
That morning, hold on, I have to scroll down. Victims and their families should have the right to hold these companies accountable when their negligence causes death or catastrophic injuries to their loved ones.
Okay, I'm the author of this bill and the chairman of this committee, and I wholeheartedly agree with what you just said.
Thank you. I appreciate that.
Just to be very clear.
I appreciate that.
Thank you for your testimony. Tell me your name again.
Matt Martin.
Matt Martin. Okay, Matt, I've got you here on behalf of, I've got you as yourself as an attorney registered against the bill. Is that correct?
Yes, sir. I was not expecting to testify today, as I mentioned, but I'll start. My name is Matt Martin. I'm here in opposition to House Bill 4688. My clients, Jason and Jessica Sprague, they waited here for 11 hours. Fortunately, they had to leave. It was so important for them to be here today
Understand.
that they spent about 11 hours away from their 8-month-old, and they've never been away from her for more than 3 hours.
Please give them my sincere apologies for our schedule.
No worries. The reason why it was so important for them to be here is because they lost their 15-month-old son in a crash with a commercial motor vehicle. That driver T-boned them and struck the vehicle right where their son's car seat was located. And they came to me for answers. They wanted to know why this happened. And what we found in the case was that while they were giving CPR to their dying infant, the truck driver was texting with his wife about getting urine to beat a drug test. We later found out that he beat the drug test because the company allowed him to go home, and they gave him about 24 hours to beat it. We also learned that after, through discovery in the case, that the driver had been terminated from his previous employer for refusing a prior drug test. So at the time he was driving, he was actually disqualified under the federal regulations. And it really paints a stark picture of how preventable this crash was, and not just because of the driver's actions. To really tell a story about why they lost Colton, why Colton died, is you have to slingshot things back and point to the fact that the man never should have been behind the wheel, but the company didn't do what they needed to do, and they allowed a disqualified driver to drive that day, and he obviously had drugs in his system. I never got him to admit it because he pled the fifth the entire time. Okay, but Colton didn't just die because of the actions of a driver who ran a stop sign. Colton died because of the actions of a company who put that unfit driver behind the wheel. And so you can't tell the story of Colton's death without the story of that company's actions. And I will tell you that the company, there was a discussion earlier about companies deflecting blame, trying to add other parties, things of that nature. They blamed TxDOT for not having no signs to warn this driver that he was approaching a stop sign. And so when we talk about comparative fault, it is extremely important to make sure that everyone is held responsible. Because I had a company blaming a TxDOT for a lack of signs when they were the ones who put that man behind the wheel. The reason why it was so important for Jason and Jessica to be here is they want to make sure that the roads are safe for all Texans, and that companies do their best to put safe drivers behind the wheel. And if a company can hide from the truth of what they're doing in their hiring practices, they won't get safer. And I don't have a timer in front of me. So,
Go ahead. You can get to a stopping point, but go ahead.
In closing, I just want to say thank you for letting me to speak on such short notice. And I can't tell you how much Jason and Jessica love their son. And the reason why they lost their son was because of the actions of the company that put that man behind the wheel. And I can tell you that with certainty. I took 25 depositions in that case. That's how hard they fought me. Okay, and it was not just about that driver.
Did you ultimately recover a judgment against the company?
It settled on right before trial.
Settled. Okay. When was the accident again?
It was July 24th, 2022.
2022.
Yes, it was after the bill.
After the.
It was after HB 19 was initially enacted. Yes, sir.
And you were still able to bring a claim, an independent claim of negligent entrustment against the company.
Yes.
And you're saying that this bill would have not allowed you to do so?
I don't believe that it would have because of some of the exceptions that were initially in the Lucio amendment, because of the violations that the company had of the actual regulations and the clear standards that the regulations set forth when a company is supposed to make sure they don't hire disqualified drivers. I believe that would have played a significant role if they were to get into a crash, say on October 2nd, 2025. If this bill were to pass in its current form, I do not believe that we would have succeeded in holding that company's feet to the fire and holding them accountable as we got closer to trial.
Vice Chair Johnson.
Thank you. I know when Chairman Leach says what he says about caring, about hearing these stories, I can tell you he means it. Thank you for all three of you with sharing the loss of your family. Nobody would ever choose to be here or have to be here. And the fact that you have been willing to be here all day and wait all night to make sure that your loved ones are remembered and that the tragedy that has happened to you can help us make better policy decisions, we are eternally grateful. And so thank you for sharing, but I am going to direct this question to the attorney because just as I asked the other one, you've heard it, trying to make sure this bill works, and I'm still confused. And so I appreciate you helping me.
Yes, ma'am.
And it sounds like what you just wrapped up with Chairman Leach. You said that there was a violation of CFR because the driver in your particular circumstance should have never been hired. That was negligent hiring?
It was
Is that right?
negligent hiring. There was also negligent entrustment.
Okay.
There were some additional things that were uncovered. To give you another example, Chairman,
Let me just stay with the one I got,
Yes,
so I
ma'am.
don't get more
Okay,
confused.
of course.
Okay, but you said, if I remember, you said it was a violation of CFR because they were disqualified driver because they had a prior incident.
it's because he refused a prior drug test. That's treated as a failed drug test. And-
Prior to the wreck.
Yes, ma'am.
And so just to get that right, it sounds like what we're saying is the idea of him not stopping at the stop sign and T-boning your clients and killing the child, that prior refusal to do a drug test, which is a federal violation, was able to come into the trial or could have come into the trial because of his bill 4 years ago in the Lucio Amendment,
It was going to come in at our trial.
because it met an exception of a violation of a federal law.
Yes.
In contrast, the fact that he then went home and tried to manipulate the drug test, that would not come into the trial because that's a subsequent issue.
That would have come in because it was evidence of impairment in the fact that
Okay.
he cheated on the drug test. I mean, like I said, he pled the fifth. We're kind of getting into some legal nuances there, but that was going to come in as evidence of impairment.
So effectively, one was about his individual conduct, and the other was about the company's negligence in having somebody that would do that on this day as part of driving their truck.
Yes, ma'am. Because there's the causal nexus. We don't want companies to hire drug users to get behind the wheel of an 80,000-pound vehicle. In this case, we had a known drug user. He was hired because the company didn't do what they needed to do. On the day of the incident, he's texting about cheating on a drug test, and so that was
He's texting the company or texting his wife?
texting his wife.
And then you mentioned, and the other lawyer said this earlier, which when Representative Dyson was asking, they said, hey, let's bring in a third party. So you've got your child victim, you've got the trucking company, their driver, and then you said they brought in TxDOT.
Yes, ma'am.
So if the language as is now, what is your understanding, if this bill were to pass as is, how that would play out in what I keep hearing is phase one with TxDOT, drug, driver, and company that hired somebody that had failed prior test or refused to take one?
My understanding, and I do apologize, I haven't, I wasn't preparing to sit down and answer
Yeah,
a whole lot
sorry.
of questions, but let me tell you what I think. I think that.
Will you do me a favor? Well,
Yes.
go ahead and tell us what you know.
I think under the bill in its current form, or this current bill, what it would do is it would not allow us to get into the fact that this man had had been terminated for refusing a prior drug test, that the company did not send the prior forms, the required forms to the previous employer, that they failed to monitor this man for his random drug tests. That was another issue in that case. They essentially would tell him at 8 a.m., go take your drug test, and it was just, you show up by 5, and no one's watching them. So we had a lot of issues with drugs in this case. And my concern is under the current bill, the only thing that would come in that would be drug-related would be the fact that he texted his wife after the crash about getting urine for a drug test, or that his wife texted him after the crash about giving him urine for a drug test. I believe everything that happened before the date of the crash, as I read the bill in its current form, it seems like that would not come in.
And we've heard a couple witnesses, some say this makes it more restrictive, some even said, hey, you'd get more evidence. It seemed to me, based on Chairman Leach's old bill, that was a clear violation of the CFR and is an exception that comes in. And I think that's the question of, does this language change make that better or make it worse? And so I know you said, I think you were starting to say you hadn't really kind of dug into the bill because you weren't prepared to do this. Would you be willing to do that based on this question? And would you reply to the entire committee if you can help answer that question if you need the time to look at it? Why are we getting two different people telling us two totally different things about more comes in, more doesn't come in? Is that fair? And I don't want you to guess, so that's why I say, if you'll look at it and just email Chairman Leach and send it to the entire committee so that as we continue to talk about this issue, we have your input based on the fact pattern you just told us. It was a very clear example of where we are.
Yes.
I appreciate it. Thank you, Chairman.
Thank you,
It was a very, as we continue to talk, just about look at it. Why are we getting two different people? Witnesses, some say this makes it more restrictive. Some even said, hey, you'd get more evidence. It seemed to me, based on Chairman Leach's old bill, that was a clear violation of the CFR and is an exception that comes in. And I think that's the question of, does this language change make that better or make it worse? And so I know you said, I think you were starting to say you hadn't really kind of dug into the bill because you weren't prepared to do this. Would you be willing to do that based on this question? And would you reply to the entire committee if you can help answer that question if you need the time to look at it? Why are we getting two different people telling us two totally different things about more comes in, more doesn't come in? Is that fair? And I don't want you to guess, so that's why I say, if you'll look at it and just email Chairman Leach and send it to the entire committee so that as we continue to talk about this issue, we have your input based on the fact pattern you just told us. It was a very clear example of where we are.
Yes.
I appreciate it. Thank you, Chairman.
Thank you, Vice Chair. Members, questions? Representative Dyson.
Just a follow-up for you, sorry. Had the name Mr. Martin right.
Yes, sir.
Just follow up. So I'm trying to understand this third party because conceptually I hadn't even thought of that, and I'm trying to work through it now that you have this other defendant that's there. When I'm looking at the law, there was TxDOT in that case.
They were added as a responsible third party.
But did it actually get joined or?
Under the current framework, all a defendant has to do is just plead
Right.
that someone is a responsible third party. In all candor, in the, I think 2 weeks before trial, they withdrew that designation because they knew it wasn't going to fly at trial. But we fought it the whole time. And earlier someone said, well, if you blame what if the driver blames the company? I see that happen, where drivers will say, well, the company was running me ragged, they were having me manipulate the logs, things like that. If a driver says something like that on the stand at trial, and the company's, not on the charge, or this bill is bifurcated, that's going to be a concern because the company may say, well, the jury may say, well, it's the company's fault, not the driver. Juries are often sympathetic toward drivers in those situations. And so if they hear this negligence of the company and the company's not going to be on the charge, that's going to create a problem, especially for a plaintiff who's lost a loved one or has, been incredibly injured.
Okay. So in your case, you didn't actually have a third party. There wasn't another defendant in your case at that time.
We had.
Right. You decided not to bring because you can bring in the responsible third party as a plaintiff, right? If someone
I
doesn't
elected
make
not to
them,
do
you
that because I
could,
thought it was a frivolous claim.
Okay.
But we fought the TxDOT argument all the way until right before trial.
Yeah, I'm just trying to understand because the law, I think as it's written now, talks about the claimant can't introduce that evidence. So I was trying to look and see could that extra defendant bring in the evidence that y'all are talking about what the trucking company has done when we're talking about comparative negligence, but I don't think it applies to your case. So I
Yeah,
appreciate
they were
that.
never. It was an empty chair.
Yeah,
They were never
appreciate
actually
that.
there.
Thanks.
Members, other questions for the panel? All right, thanks to each of you for being here.
And thank you again for allowing me to testify on such short notice.
Please give our condolences to your clients. The chair calls Jody Scott, Melissa Traylor, Victoria Limon, and Marie Navarrete. Scott, Melissa, hi. What's her name?
Her name is Aubrey.
Is Aubrey going to testify?
No, she's just holding up a picture.
Okay, does she want to sit? Her name is Melissa. Okay, thanks.
My husband's car was stopped behind a getaway, letting kids off. So what was? And they're just as much as fault